Hi, everybody. This is Charles C. Ballmeyer, Vice President of NetLaw, and welcome to our workshop. I thank you very much for giving me your time on this Saturday. I know you have better things to be doing today, so thank you so much. I hope you get a lot of benefit from your time with me today. I want to talk about some very important issues and go through in detail how you actually use your NetLaw account to create documents for yourself. But real quick, let me tell you a little bit about our company. NetLaw is a technology company that was actually created by the law firm of Hargrove Madden, which is an estate planning law firm based in Louisville, Kentucky. Our technology was recognized by the American Bar Association in 2012, and we were awarded their James Keane Award for Excellence in E-Lawyering. What we decided to do with that at that time was really move this into a different platform so that we could better serve our clients and make the whole process easier for them, and thus NetLaw was born. Here are the documents and services that are included in the plan. You get a last will and testament, probate avoidance revocable living trust, financial power of attorney, medical power of attorney, living will, also known as an advance directive, HIPAA authorization, a life vault, which is a wonderful tool for you as a client. So once you create these documents, you can store all of these documents in your vault. It is a secure encrypted environment, cloud-based environment, so that you can access these documents at any time. But you can also store anything else in the vault, and I would really encourage you to do so. You know, if something were to happen to you, this is a great place and a great resource for your family so that they have one place they can go to find everything. So I'd really encourage you to put copies of your life insurance policies in your vault, your bank statements, your investment account statements, retirement account statements, all of your asset information I would put there. But you can put anything else, you know, copies of passports, birth certificates, even photos, all of that can be saved in your vault. And I also encourage you to really work closely with the advisor that referred this plan to you. They're a wonderful resource for you, and they're more than willing and happy to help you get these documents scanned into your vault. If you're like me, you don't have a scanner at home. My printer doesn't even work, so that can be a bit of a problem. And you know, just to have all of that stored in one place that you can access anywhere, anytime with internet access is a great, great tool for you. So I encourage you to do that. Also included in the plan is access to our national network of estate planning attorneys. These lawyers are vetted for their experience and expertise in estate planning. So if you have an issue or a particular situation where you need the extra help of a lawyer, these attorneys are available and very capable of helping you. So maybe you have a child with special needs and you need a special needs trust, or perhaps you're a business owner and you need to talk to someone about business succession planning. These lawyers will be a great resource to you. Keep in mind, however, that their time and their services are not included in your plan. That will be at an extra cost, and that will be based on their fees and their hourly rates. What is included in the plan, however, is your spouse. If you are married, your spouse can create the same set of documents at no additional charge. So that's 2 sets of documents for the cost of one plan. So that's a wonderful benefit to you and your family. I want to talk about some of the estate planning issues that come to mind when you start thinking about planning. You know, what's really important to you, and what are some of the maybe the hurdles or hesitations you might have when even going down this road or even completing the process of getting your documents in place. And it really boils down to kind of 3 key issues for most people. Number one, we all want to maintain control. I don't think any of us are ready to give up control of our money or our financial decisions or our medical decisions. We want to maintain control over that, especially, you know, your healthcare decisions while you're living. I mean, that's a huge, huge thing for everyone. But, you know, with maintaining that control comes financial security. I've been in this business for at least 20 years, and I have yet to meet an individual who was ready to turn over control of all of their money to someone else. we don't want to do that because we need to maintain that financial security. We want to invest our money the way we want to invest it. We want to be able to spend it the way we want to spend it. And we want to be able to leave that to our loved ones the way we choose to do so. So those are two key issues that are really tied closely together. The next issue that is really important to a lot of people is just preserving your assets and managing those assets, not only for future generations, that's very, very important, but also for yourself during your lifetime. And with proper planning, you can do that. I often talk to clients about protecting your wealth during your lifetime and after your death, and protecting your health, protecting your health care and your health care decisions. And with proper planning, you can do that. So wills and trust are not just about death and dying. It's not just about after you are gone, but it's about protecting yourself during your lifetime if you have a health event. And I'm going to show you how that works and how you accomplish that with this plan. I want to talk a bit about probate. That's an issue that's a pretty big deal for some people, and in some states, it can be very, very costly. It can be time-consuming, and it can be pretty burdensome for the family. Every state has what's known as a creditor's claim period, and on average, that's 6 months. Now, it can be different from state to state, but most of the states across the country, that creditor's claim period is 6 months. And what that means is that is the minimum amount of time that the estate has to be kept open. It's also a period of time where your assets cannot be accessed by your family. The court basically freezes those assets and has to preserve them to give creditors a chance to come forward and file a claim against your estate. So it really puts a burden on the family. It keeps them from having access to those assets and those funds to buy groceries, to pay the light bill, just to basically continue the lifestyle of the family. A great way to avoid that whole process is with proper planning, with trust planning, a revocable living trust that we'll talk about in just a moment. Now, regardless of whether or not you die with a will, which is known as testate, or if you die without a will, which is known as intestate, any of your individually owned assets are going to be subject to this probate process. Now, an individually owned asset is something that has a title with just your name on it. So a piece of property with just your name, a bank account with just your name, a car that just has your name on the title is a probate asset. And those are the types of assets that are going to be subject to court jurisdiction. Those are the type of assets that are going to be frozen by the court for that creditor's claim period. Now, there are other types of assets that are not subject to probate, and those are non-probate assets. And that would include anything that passes by beneficiary designations, such as life insurance or retirement accounts. Those are going to pass by the designation, that beneficiary designation that is attached to that asset. Likewise, assets that are owned jointly with rights of survivorship are going to pass automatically to the survivor. So regardless of what your will might say, those assets are going to pass according to the terms of the beneficiary designation or automatically to the survivor of anything that's owned jointly with rights of survivorship. Other assets that escape that probate process are assets that are owned by a trust. And we're definitely going to talk about that and how that's not only beneficial from avoiding probate, but how it's also beneficial for you during your lifetime and your family after your death. One thing to note is that if you effectively avoid probate, that doesn't necessarily mean that you avoid paying taxes. Your taxable estate and your probate estate are not necessarily the same thing. Again, your probate estate only includes assets that are owned by you in your individual name. Your taxable estate includes everything, including those assets that pass by beneficiary designations, such as life insurance and retirement accounts, including assets that pass jointly with rights of survivorship, and including assets that are owned by a revocable living trust. So it includes everything. Just want to make sure that that's clear, because sometimes people, I think, have a false sense of security that if they have a revocable trust and have it funded with their assets, that means that they're going to avoid paying taxes at their death, and that's just not the case necessarily. So why execute a will? And what does that really do for you when you have a will? You know, that is, again, whether, to go back to that whole probate process, whether you have a will or you don't have a will, that whole probate process is really, it's something that kind of pulls together all the loose ends of your life. And if you have a will, then you name the person known as an executor or a personal representative that's going to be responsible for handling all of that. If you don't have a will, the court is going to appoint an administrator to do that for you. And it's a pretty important role, so I think that's something that you want to be in charge of, naming someone to have that ability. Your executor is going to be someone who's going to basically take an inventory of all of your assets, have them valued. They're going to distribute them either according to your will or according to state law based on whether or not you have a will. And that's also the person that's going to be responsible for paying final debts and expenses. That's the individual that's going to be responsible for filing your final income tax return. You know, believe it or not, the IRS is not going to give you that year off just because you passed away. You know, they're going to want that final income tax return. So that's one of the responsibilities that your executor or your personal representative will handle. Now, another important reason why you should create a will is so that if you have minor children, you name a guardian to take care of that child. A guardian is someone that basically steps into your shoes as a parent to have the physical care, custody, and control of that child. So what happens if you don't do that? Now, I have a minor child. My daughter is 10. And, you know, my husband and I decided a long time ago who we wanted to raise our daughter. But if we had not named that person in our wills, because that is the legal document that courts recognize, a judge would make that decision. Now, even though we may want my sister to raise our daughter, if we didn't have that in the will, what's to say that my husband's sister wouldn't think that we wanted her to raise our daughter? And you could potentially have family members fighting over the custody of a child, and a judge really doesn't know what you really would have wanted to happen. You know, that judge doesn't know you, doesn't know your family, doesn't know your wishes, doesn't know your child. You know, in some of the worst cases, I've seen children placed in foster care temporarily until the guardianship can be worked out. And that's just a very traumatic event to put on a family and your children. So it's one of the reasons why you really need to take this step. If you yourself do not have minor children, maybe you have minor grandchildren, make sure you talk to your kids about that and make sure that they've got that not only decided, but set out in a last will and testament. Of course, your last will and testament is where you let everyone know, your family, your loved ones, a judge, how you want your assets to be distributed. Without having that within your last will and testament, it's going to be passed according to state law. So what I always tell people is if you don't have a will, your state has one for you, and it's that intestacy law, that intestate succession law. It's going to dictate how your assets pass, and more than likely it's not going to be according to your wishes. So those are some very important reasons why you should create a will. Let's talk a little bit more about revocable trust, and I touched on that when we were talking about probate. And with that trust, and I'm just going to elaborate on that a little bit before we go into the other benefits, but having a revocable living trust and naming that revocable living trust, having that revocable trust be the owner of your individually owned assets prior to your death will keep you from going through that probate process. So rather than having that piece of real estate in your individual name, you would want to have that piece of real estate owned by your revocable living trust. You would want your bank accounts owned by your revocable living trust. Anything in your individual name that you wanted to keep from that probate process, it's a good idea to utilize that trust for that purpose. Because what happens at that time when you pass away, you did not own those assets individually. Your trust did. So it's not subject to that court process, which means it's also not subject to that 6 months creditor's claim period. So your family has immediate access to those funds to continue to pay the bills and buy groceries and keep living just like you would want them to do. So that's one of the major benefits of a revocable trust. Also is the privacy that comes with that. You know, probate is a public process. Again, the court has to publish notice of your death and to give those creditors a chance to come forward. That also means that anybody has an opportunity to take a look at your file, your estate file. They can see what you have, what it's valued at, and who it's being distributed to. That's not the case with a trust. These revocable trusts are not subject to court jurisdiction, so all of that remains private. First and foremost, though, let's talk about the flexibility that this trust gives you. And let's reflect back on those three key issues: control, financial security, management and preservation of assets. With a revocable trust, you are your own trustee during your lifetime, which means you maintain complete control over that trust. You can change it at any time. You can change the beneficiaries at any time. You can put assets into the trust. You can take assets out of the trust at any time. It's at your complete control, which means you maintain complete financial security from those assets. In addition, it gives you the benefit of being able to manage those assets not only for yourself during your lifetime, but for future generations. Again, a lot of times people think about wills and trusts as tools that come into play after you pass away. With this revocable trust and with the financial power of attorney that's included in the package, those are key tools to protect your wealth for yourself during your lifetime. What happens if you have a health event? What happens if you have a stroke or develop dementia? With these documents, you can have your power of attorney can move your assets into your trust if you have not already done so, and then the successor trustee named in your trust can then take over the management of those assets and continue to pay bills and buy groceries for the family and make distributions to and for your benefit, just like you would want to happen, because that's your trust. That's how you've designed it. So this is a key disability planning tool for you during your lifetime. Now, upon your death, again, this is a key tool to preserve and manage those assets for future generations. A lot of times we're protecting inheritance not only for the beneficiary, but sometimes from the beneficiary, from spendthrifts, from future ex-son-in-laws and daughter-in-laws. I mean, I don't know about you, but I can already tell you that I want my daughter's inheritance to benefit her and my future grandchildren. I definitely don't want my daughter's inheritance to potentially go to my future ex-son-in-law and anybody that he marries after her and any children that he may have after her. I don't want that to happen. I want it to stay in my family, benefiting my bloodline, and this is how you do that with proper trust planning. I will point out that during your lifetime, there is no tax advantage, no tax benefit of having this trust. And why is that? The reason for that, again, is because it is at your complete control. Remember, you control it. You can put assets in, which means you can take assets out. You can change the terms of the trust. You can completely terminate the trust. So the trust maintains your Social Security number. So there's no separate tax filings that you have to make every year, which is good. But that also means that it doesn't benefit you from a tax perspective either. In addition, this particular type of trust is not an asset protection trust, which means you cannot set up this trust today and move all of your assets into it and then file for bankruptcy tomorrow and have those assets protected from bankruptcy. The judge is going to say, well, that's all well and good, but go get those assets out of your trust and pay your bills. So again, if you maintain the control, the access, and benefit, those assets are not going to be protected from, bankruptcy, from creditors, and that kind of thing. So I want to make sure that that's understood and that that's perfectly clear. So I want to talk a little bit also about financial decisions and transactions and medical decisions. With your financial power of attorney, I've already talked about how that's a key tool in helping you not only during your lifetime, but if you have a health event. So, again, if you have that stroke or you become mentally incapacitated or whatever the case may be, your power of attorney and your trustee of your revocable living trust work together to make sure that you're taken care of and eliminates the need of a family member of having to go to court and be appointed as a guardian to handle those things for you. So the individual or individuals named in your financial power of attorney have the ability to handle your finances just like you would for yourself. So they can write checks to pay bills, they can vote stock, they can buy and sell real estate, anything like that. With your medical power of attorney and your advance directives, those control health care decisions. So the medical power of attorney, you name someone or a couple of people, it's up to you, to have the ability to make medical decisions for you if you cannot do so for yourself. So if you cannot speak or communicate for yourself, the individual or individuals named in that medical power of attorney can consent to treatment on your behalf, or move you to a more specialized facility, or consent to a particular procedure. That's the kind of decisions that are controlled by that document. With your living will, also known as an advance directive, that's the document that controls your end-of-life decisions. So artificial nutrition, hydration, and respiration, that's what that controls. If you feel very passionately that you be allowed to die naturally without those artificial interventions, you need to let your family know. On the flip side of that, if you want to be kept alive, no matter what, that's okay. That's your decision, but you need to let your family know. And if you really want to ensure that those wishes are followed and that the physicians and healthcare providers are legally required to honor those wishes, guess what? You have to put that in a legal document. Without that, again, a judge is going to appoint somebody to handle that for you. Now, I don't know about you, but it may take me, maybe a second or two to figure out who I would want to make those decisions, but I automatically know who I would not want to make those decisions, right? I think we all know that. And again, a judge doesn't know what you would want and what you wouldn't want. So avoid that situation, avoid, kind of the risk that you might be taking by making sure you have that in place. So, what is your legacy? What do you think you'll be remembered for by your family? Do you want to make sure that you're not only protecting yourself during your lifetime, but that you're protecting your family after you're gone? And, first of all, I commend everybody on this call for taking that step. You've taken that first step. And I hope that you take the next steps to really get through the process and get everything completed.